بسم الله الرحمن الرحيم لا حول ولا قوة إلا بالله العلي العظيم الحمد لله رب العالمين وصلى الله على سيدنا ونبينا أبي القاسم المصطفى محمد
اللهم صل على محمد وآل محمد
وآله الطيبين الطاهرين لا سيما بقية الله في الأراضين أجل الله تعالى فرجه الشريف اللهم أخرجني من ظلمات الوهم وأكرمني بنور الفهم اللهم افتح علينا أبواب رحمتك وانشر علينا خزائن علومك برحمتك يا أرحم الراحمين. We studied Qa'idatul Ghurur, and now we want inshallah to study al-Tasbib, Qa'idatul Tasbib. And these two are similar, but we said there are differences. Because in ghurur there is a deception. In tasbib there might be no deception. So in the same lesson about Qa'idatul Ghurur, in the second half there is a title Qa'idatul Tasbib. Tasbib, as we said, comes from sabab. Sabab means cause. Tasbib means to cause something. Like when you ask someone to do something. For example, sometimes a person may ask a child to give this letter to someone. Or may say, to someone, go and break the window of someone or kill someone. These are like tasbib. In some early texts, sometimes they say as-sababu aqwa min al-mubashir, means the one who is behind and causing, sometimes it's stronger than the one who is actually doing. Mubashir is the one who is doing something. Yeah. The last one is called mubashir. So if A asked B to kill someone, B is mubashir. Yeah? But A is sabab. Al-fa'ilu bit-tasbib, al-fa'ilu al-mubashir. So sometimes they say as-sababu aqwa min al-mubashir. In any case, this is when someone causes another person a kind of loss. A causes loss for B. We had an example, and we repeat this example again today. لو نجس شخص قطعة فرش لغيره. If someone makes carpet of another person najis, and this carpet has to be clean. وَكَانَتْ طَهَارَتُهَا أَمْرًا ضَرُورِيًا. For example, this is the carpet on which they pray or they eat, whatever, it has to be clean. Now to wash this and clean it, ritual cleaning, to do tathir, it may cost. They have to take it to the, there are some workshops or factories that they clean carpets, they wash them. So the one who made this najis has caused a kind of expense for the owner of this carpet. So he has to pay for this cost. Even if the owner is paying, but he can claim it from the person who made it najis. If we believe in this qaida. لو نجس شخص قطعة فرش لغيره وكانت طهارتها أمرا ضروريا واحتاج التطهير إلى أجرة معينة. And cleaning and washing needs certain amount of money to pay. فبناء على تمامية قاعدة التسبيب يلزم المنجس ضمان تلك الأجرة or يلزم المنجس ضمان تلك الأجرة. What becomes on the necessary on the shoulder of munajjis is dhaman for that ujra. He would be liable for that cost. And if in this process the carpet is also damaged, there are some carpets that if you wash them, the color will be, damaged. If the value of carpet also goes down, he is responsible for the value of the lost value as well. So the value of the washing and the value of reduction of the price. Ayatullah al-Uzma Khuyi rahmatullah alayh, he didn't accept this. He said, in fiqh we have only two reasons for dhaman, for liability. One is al-itlaf, when you destroy something, and one is yad. You remember we said if without your permission someone takes your car and the car is damaged, even if he didn't decide to damage, it's not that he destroyed or damaged deliberately, just an accident or someone stole the car. Ayatollah Khuyi says we have two reasons for dhaman in fiqh. Al-itlaf, man atlafa mal al-ghayr fahuwa dhamin. Yeah? If you destroy someone's property, you are liable. Or ala al-yadih, ma akhadat hatta tu'addi. And he says, in this case, we don't have neither itlaf, nor yad. Why? Because the carpet is not damaged. In the case of washing, the carpet is not damaged. And he has not taken the carpet with him. So there is no yad. Why he should pay for tathir? This is Ayatollah Khuyi says. So he says, أن سبب الضمان منحصر بأمرين. What causes liability are only two. Al-itlaf wal-yad. Al-itlaf, من أتلف مال الغير فهو ضامن. اليد على اليد ما أخذت حتى تؤدي. وكلاهما غير متحقق. None of these two is applicable here. Because he has not damaged, because najasa is not damaging. Okay? And he has not taken the carpet with him, so what say على اليد ما أخذت حتى تؤدي. إذ بالتنجيس لم يتحقق إتلاف قطعة الفرش ولا الاستيلاء عليها. So there is no reason to say it is damaged or there is yad. Is it clear? Yes. If there is such a case that just making najas reduces the value of the carpet, that's something that he's liable for it. But normally, it's not reducing the value. Then Ayatollah Khuyi rahmatullah alayhi says, at-Tasbib fahuwa laysa sababan mustaqillan lidhaman. He says, Tasbib by itself is not an independent cause for liability, independent reason for liability. In contrast to itlaf and alaliyad. It only causes liability if it leads to those two, itlaf or alaliyad. Now let's give you example. Sometimes it can be a case that it is tasbib, and also one of those two applies. There is zaman, but it's because of those two. And we give you example when there is tasbib, but neither itlaf nor alaliyat applies. Okay? The first example. Imagine لو أرسل شخص دابته. Someone has a horse, or has a cow, or has an animal anyway, and sends it to the farm of another person. أتلفت ذرع الغير. This cow goes to farm of neighbor, and he sends the cow there and damages the farm of the other person. Okay, they have planted, something, and this cow goes and eats. Okay, there is itlaf. أو أعطى شخص سكينا بيد صبي وأمره بضرب شخص. Someone has an enemy. The enemy is sleeping, for example. He doesn't want to kill the enemy. There is camera, or people can't. So there is a child, says, take this knife and test it on that person and see whether this knife is working or not. So he deceives this child. So here we can say this person is sabab, and at the same time he is causing itlaf. Whether he sends his animal or he sends a child, he is causing this problem, and he's causing damage. Yeah?
Was he aware of the horse going to the other farm?
Pardon?
Was he aware of the horse?
Yeah, arsala. Arsala shakhsun dabbatahu. He sends his animal. He think that it's good, we feed, our animal from that grass. So here يصدق على الشخص المذكور عنوان المتلف. We can say he is doing itlaf because he's doing itlaf of zar'ul ghayr, the farm of the other person, or doing itlaf to the life of someone. Why here people say he is mutlif? There's a very beautiful point here. Because what is between sabab and the action is an animal or a child who either has no willpower or has very little will. So uqala put all the blame and responsibility on the person who is sending the animal or sending the child. They say you are musabbib and mutlif. That's all? It's okay? But if there is an adult, rational, healthy person who has irada, لو أمر شخص شخصا آخر كبيرا بإتلاف ذرع الغير. Someone says to another person, go and destroy farm of so and so. If this person goes and destroys the farm of so and so, he has caused this, but uqala, they don't say he has damaged it. Yeah. So because the mubashir has willpower, so he can say, I suggested to him, I told him, but he could have refused. So when someone is sabab and mubashir is animal, is a child, is a mad person who is very vulnerable, cannot make decision, blame goes to sabab. But when mubashir is a person who has understanding, who has willpower, he is responsible, he is mutlif. Maybe there is some level of responsibility for this person, but he is not considered as the one who has damaged. Yes.
If someone hires a killer to kill someone,
Yeah.
and the person kills, obviously the main person is the sabab who is at the back, not mubashir.
Yeah.
So what will be the distribution of punishment?
So they are both going to be punished, but the punishment of mubashir and sabab are different. But they are both going to be punished. So لو توسطت في البين الإرادة التامة للمباشر. If between sabab and the action there is mubashir and has a very strong willpower. لو أمر شخص, this is the example, someone commands as B, who is also adult, who has grown up, is a person with understanding, says, go and destroy farm of a third person, or go and injure him. And this second person does that. Here we say this mubashir, the one who has actually done that, is mutlif, is doing the damage, not the sabab. This is what Ayatollah Khuy rahmatullah alayhi says. So he says, I repeat again, Ayatollah Khuy rahmatullah alayhi says, in fiqh we have only two ways that someone becomes liable. One is itlaf, man atlafa mal al-ghayr fahuwa dhamin. Second is ala al-yadma akhadat hatta tuaddi. You take someone's car without his permission, and then the car is broken or someone hits the car. You have not done itlaf, but anyway the car is damaged or lost. You are responsible. He says we have only these two cases. If tasbib leads to these two, for example, musabbib is considered mutlif, he is responsible. When musabbib is considered as mutlif, when the mubashir, the agent who is actually doing it, is a child or animal who has no strong control and a strong willpower, then sabab is also considered as mutlif. But if there is a person with understanding, with a strong control, who is persuaded by sabab, sabab is not considered as mutlif. He is not zamin. Though he may be punished, he may be responsible.
Can I ask a question?
Yes.
For example, if you take the case of Yazid and Ziyad, Yazid sent people to kill Imam Hussein. Ziyad carried al Mubashir. He was a causer. So both of them are liable.
Even Ibn Ziyad was not Mubashir. Even Ibn Ziyad was not Mubashir. Because Ibn Ziyad also sent another army. Yeah.
So what happens in this case?
So they are all responsible, but the one who actually does the murder, Mubashir, his responsibility is in a sense different. So if there is a punishment for murder, might be given to this person, and those people are responsible for persuasion of murder. They are not murderer technically, but they can be also punished.
For example, when we see some of the governments, they send their armies to kill other people.
Yes.
So army is not going to go unless they have the permission from.
Yes.
So that they are the main people to be punished, sitting at the back.
Yeah. So they are responsible morally. Legally depends on the law. How that law is, made. Whether they are equally responsible or people who are actually higher have more responsibility. But what is important is if, for example, there is a kind of qisas or whatever, we have to see the legality. Is qisas for any person who caused or the last one who is actually physically involved? So these are legal issues. But morally, everyone is responsible. Even morally, the people who hear this and are happy with are also morally responsible. سَمِعَتْ بِذَلِكَ فَرَضِيَتْ بِهِ. Even those who are happy, they are responsible. But legally is different. There is another issue, another mas'ala, another problem that fuqaha have discussed. If a person like Zayd, na'uzubillah, makes Quran najis or makes masjid najis, you know, cleaning of Quran or masjid is necessary and has to be done quickly. Yeah, you cannot delay it. So to clean this Quran or to clean masjid, we might need to pay someone to take it and clean. Who is responsible? Zayd is responsible who has made it najis, or all Muslims are responsible because it is wajib kifai on Muslims to clean this, whether it's masjid or Quran. Even if you have not made it najis, you have to do something. It's wajib kifai. So who should pay?
The one who made najis.
The one who made najis, or everyone is responsible to pay this so that it is sorted out. If we believe in qa'idat al-Tasbib, we say Zayd has to pay because Zayd has caused this najasa which has caused tathir. Why we are doing this washing? Who caused this headache? Zayd. So if we believe in qa'idat al-Tasbib, Zayd has to pay. But this is not qa'idiyya itlaf and this is not alaliyat. Okay? So if a Muslim realizes and goes and wash or pay for this, he can claim from Zayd that you have caused this, you have to pay for this. There is a very delicate issue here. Sheikh Irwani says, even if someone doesn't believe in qa'idat al-Tasbib, like Ayatollah Khouy, and says that we only have two ways for dhaman, one is itlaf, one is alaliyat, he says, still we may say that Zayd has to pay. Why? He says, because here, look very carefully. He says, because here, although the one who is to wash is a Muslim, but because this Muslim has no choice other than washing because wajib on him, it's like the case that we said when there is no iradiyya qawi, there is no strong control or a strong willpower, we said musabbib is responsible. Like a child. Because you are doing something that then Muslim, without having any choice, have to wash it or pay for washing it. So you are responsible. Okay? There is another example. If there is a person who is financially not stable, is mu'sir. For example, a person who is already in debt and has lots of financial difficulties. Then, if he marries and has wife and children, and he cannot pay the living cost for the wife and children, who has to pay? The community, Muslims have to pay for the cost of this person. Okay? Because they cannot let someone's wife and children die without food or without shelter or without medicine.
Like a taxpayer in this country?
For example. We have to pay. Now, if we realize that this sheikh actually arranged, for example, the marriage of this person, or this mu'min has helped this person to marry, can we go back to him and say, why you married him and caused this much cost on us? If he was not married, it was easier. He says, this is not something that Orf accepts. No one says that here you have caused liability or, loss and this type of things. لا يمكن التزامه. No one can accept this.
There is an issue here, if you don't mind.
Yes.
In the Surah al-Iqrar, it says, إن كنتم فقراء فيغني الله.
أن يكونوا فقراء يغنيهم الله من فضله.
So the poor man can marry, and God will. So how do you put this together?
So
how do you answer to this?
So one way of making them rich is Allah asks people to help them. So everyone has to help them. Now, can those people who have helped come and claim from the one who managed and arranged the marriage that you have to pay us back? Or another example, this example is also very interesting. Someone was in debt, so Hajj was not wajib on him, because if you are in debt, Hajj is not wajib. Yeah? Of course, there are some cases that maybe, for example, if you have installment, to pay installments, and then you have job, and maybe it's okay. Like someone has mortgage, but still he has job. But suppose someone has debt, and the debt is due, he has to pay now, but he doesn't have money. Okay? So because he is not mustati, Hajj is not obligatory. Someone says, I pay you for your debts. So when he pays his debts off, he becomes mustati. Now he has to pay for going to Hajj. Can he say, you caused me some expenditure? Now I have to pay for Hajj. Again, here, we don't consider this type of things as tasbib. We don't say they have caused loss. Yeah, so here we agree with Ayatollah Khouyi that this kind of tasbib, because Ayatollah Khouyi is against tasbib being independent. He says only itlaf and alaliyat. We agree here with Ayatollah Khouyi that yes, in such cases, this causation or this tasbib is not causing loss. Yeah, although if you look at it from surface, you think yes, you have caused loss, but it's not loss. We know that Shari', the legislator, is happy and indeed recommends us to help people marry or to help people pay their debts. So this recommendation of Shari' shows that we should do this. It's like when Shari' says that you have to wash the najis, so we have to wash it. Ala tahal, qa'idatul tasbib seems to be different from qa'idatul ghurur. It seems it can cause liability, but it depends on Orf recognizing liability, because the main reason for this is Orf. Now there is a question. We go back to qa'idatul ghurur. Qa'idatul ghurur is when there is deception, someone deceives another person. Is this conditional upon the person who is selling or buying or recommending being aware or not. And also the other party should be ignorant or not. For example, let me give you a straightforward example. I give you someone else's food. I know it's not mine. It's someone else's. I give it to you, and when you eat, then I say it was for someone else, you have to pay. This is a straightforward, that here I am liable. I knew and you didn't know. Okay? But if I myself didn't know, I thought this is my food, I gave it to you and you ate, then the person says, this was mine. And I check, I say, yes, it was his, so please pay. Can you say you deceived me or not? Yes. So, some people say yes, because no matter whether you knew or not, you are responsible. Because if that person knew that it's not yours, he would not have eaten. But then there is another option. You know or you don't know that this is not your food, and give it to someone who knows that this is not your food. And he eats, but then when you say pay him back, he says, you told me that it's yours. This seems that it's not acceptable. If he knew that it's not your food, even if you didn't know or you told a lie, it seems that he is not able to say, I was deceived. Okay?
That last case is just ignorance, right? Because he knows he's still eating it. In the last case, the one who ate the food,
Yeah.
he knew it was not the person's to give him, but he still ate it.
Yeah.
Can you say that was just, he was trying to deceive himself?
So if he knew and still he ate, he cannot come and claim you, because he himself knew. But if he didn't know, and also this person also who offered the food didn't know, it's very difficult to say that this person has to pay him. Okay. Alhamdulillah, we finished Qa'idatul Ghurur and Qa'idatul Tasbib. Now we go to the next rule or rules actually. Qa'idata al-Iqrar. Because there are two rules which are very similar and both of them are about Iqrar. Inshallah, we'll explain both of them. One is, you have maybe heard this a lot. إقرار العقلاء على أنفسهم جائز. Admission or confession of intelligent people, rational people, about their own, death or their own harm, something that they confess about themselves, over themselves, is valid.
No, which chapter is this?
It's not available in English. It's not available in the class.
You don't have it either. So, إقرار العقلاء على أنفسهم جائز. So when uqala confess or admit something against themselves, over themselves. For example, I tell, I owe this man 100 pounds. I admit, I declare, from a fiqhi legal point of view, this iqrar is valid. Yeah? إقرار العقلاء على أنفسهم جائز. If someone goes to the court and says, I have killed this person, this iqrar is accepted. He doesn't need to bring proof that I killed him and these people bear witness that I killed him. Yeah? If you say someone else has killed then you have to bring bayyana, evidence. But if you say, I have done this, is it clear? But if you say, I worked for this person and he owes me this much money, this is not iqrarul uqala ala anfusihim, because you are saying something about someone else. It's not over yourself. So something that you undertake and you accept for yourself, it's okay, but not on behalf of other people. Is it clear? This is iqrarul uqala ala anfusihim jaiz. There is another rule. Man malaka shay'an malaka al-Iqrar bih. Man malaka shay'an malaka al-Iqrar bih. Whoever is in charge of something, malaka means ownership or being ruling and governing something. Whoever is in charge of something, his declaration is accepted. What does it mean? A person comes and says, I sold my home to this person. He is the owner, he's in charge, and he says, I sold my home to this man. It's accepted. We don't ask for proof. If we know that he was the owner, and now he says, I have sold it. Or if we made someone vakil, I said, you are my agent to sell my home. And he says, I sold your home. So we accept it. Because these are the people who are in charge, either independently or by appointment. So these are two rules. Some people have thought they are the same, they are identical. But we believe these are not the same, although we have iqrar in both of them, but iqrar means different things. So, Sheikh Tusi, rahmatullah alayh, mentioned in this qaida, man malaka shay'an malaka al-iqrar bih, and it seems before him this was not mentioned, but then our ulama analyzed them, studied them further, and they came to the conclusion that these are not the same rules. These are two different rules. So let us see few points. Madhmunul qa'idatain. What is the meaning of each of these two rules? Second, are they the same or not? If we understand their meaning, we understand what they are, one rule or two rules. Madrakul qa'idatain. What is the proof for each of them? Are there exceptions for iqrar? If a person admits, we accept all the time, or there are exceptions? Inshallah, we would say that sometimes there are exceptions. We don't accept admission. For example, inshallah we will study later, but as a preparation. Imagine they take young people to the military service. And this person says, I stole money from that shop. So that they cut off his fingers and then he will be exempted from military service. It's the example in the book. So although he is admitting against himself, but because there is a benefit that he may take from this iqrar is not accepted. Okay? According to the book. Or sometimes for admission once it's not enough. There are cases, for example, of admission. If someone does admit about fornication, sometimes once is not enough. Has to repeat admission. So we will discuss these issues. The other issue which is also interesting, can admission or confession be indirect with the implied meaning? Okay? For example, I say, I have to pay this man, or I have paid, sorry. I say, I have paid the cost of buying this home to this man. I have paid. Here, you are saying that you have paid the cost. This is not ala anfusihim. This is in your favor. But indirectly you confess that you have purchased the home. So that is his home. So you accepted that you have purchased from him, and that is what we can accept from you. But then you say you have paid for it. That is what you have to prove. You understand? So if someone goes to the court and says, I borrowed money from this person and I have paid him off, the court accepts the first part, not the second part. When you say I have borrowed money, they accept. When you say you paid it back, they say now you have to prove it. Okay? So sometimes it is clear like this, sometimes it's implied. Like it says, I have paid the price of the house to this man. This implies that this house was his, not yours. Now you have to prove that you have paid, otherwise the house goes to that person. Then we are talking about at-tafkik fil iqrar al-wahid. This is another beautiful discussion. Sometimes someone admits, but we analyze it. We say, this is analyzed into few points, we accept some and not the rest. For example, someone says, this woman is my wife. We analyze this claim. For certain things we accept, for certain things he has to prove, otherwise we don't accept. Okay? Because if anything is admission against himself, we accept. But that now he's claiming that this is his wife. This is not against this. That woman also has to accept. You understand? We will talk about it. Also, we say that we accept iqrar or confession when the person is still in charge, not used to be in charge. For example, you have a wakil, you have an agent to sell your home. Wakil comes and says, I sold. We accept. But this wakil is dismissed. And after he's dismissed, he says, when I was wakil, I sold it. This is not accepted. So, okay, we talk about all these things, inshallah. So the first thing is madhmunul qa'idatain. What is the meaning of these two rules? Iqrarul uqala ala anfusihim jaiz. And second, man malaka shay'an malaka al-iqrara bih. So, first, iqrarul uqala ala anfusihim jaiz. What does it mean? Means if you admit something which is not in your favor. If it is in your favor, you have to prove it. But you admit something which is not in your favor, something which is bringing some liability to you, or you are losing something, you have to pay something. Something which is against you. Ala anfusihim, not la anfusihim. Yeah? You admit something against yourself. This is accepted. For example, he says, my home that I live there belongs to Zaid. He admits. This is accepted. But if he says, home of Zaid belongs to me, this is not accepted. Okay? Or someone says, I have not paid mahr, dowry for my wife. So say, so you have to pay. We accept it. But if he says, I have paid mahr, we say you have to show proof. If the wife doesn't agree, the man says, I have paid mahr, the wife doesn't agree. So, al-bayyinatu ala al-mudda'i wal-yaminu ala man ankar. The one who claims that has paid has to bring bayyinah. If he doesn't bring bayyinah, the other one just says qasam and takes it. So, this is iqrarul uqala ala anfusihim jaiz. Jaiz here means valid, means it's effective, means it's something that is, followed, accepted. Yeah, it's effective. It's nafidh, is in effect. The other rule, man malaka shay'an malaka al-Iqrar bih, means whoever can do certain thing with something, whoever is in charge of something, he has haqqut tasarruf. For example, a person can sell his home, or a vakil is given authority to sell someone's home. The owner or vakil says, I sold it. You say, okay, because he was in charge, we accept when he says, I sold it. Or suppose there is a person who has the right to divorce his wife. If someone who can divorce his wife says, I divorced my wife, it's accepted. Because he has the right to do this.
What about the wife? She claims that he divorced her. Would that be accepted?
No.
No.
Because she was not able to divorce. The man has to divorce. So she has to prove.
She has to prove that her husband has given them.
Yes. So these are two rules, and as you found, perhaps inshallah clear, they are different things. One is about making a confession which is causing you some harm, some loss. Another person is about accepting declaration. It's not actually confession. It's declaration. He says, the vakil says, I sold it. He's not confessing or admitting. He's just declaring that he has done. So because he was in charge, we accept it. Sometimes we can have a case that both rules apply. Sometimes qa'idatul iqrar applies, sometimes man malaka shay'an malaka al-Iqrar bih. So they overlap. Let us give you a few examples. إذا أخبر شخص بأني قد أوقفت داري على الفقراء. Someone says, I made my home waqf, endowment for poor people. Or I made in my will that when I die, this will be given for poor people. Do we accept this or not? Yes. Why? Because it's his home and he is saying that I gave it to poor people. So, إقرار الأقلاء على أنفسهم جائز plus Man malaka shay'an malaka al-Iqrar. He's in charge of this house. He can sell it. He can give it as a gift, whatever. He says, I have given it to the poor people as waqf. So this is the case that both rules apply. It's common between them. Another example. Someone says, I killed another person, or I stole from him. Do we accept or not? We accept. Why? Because إقرار العقلاء على أنفسهم جائز. But can you say من ملك شيئا ملك الإقرار به? No, because you were not in charge of killing him. It's not that you are in charge of stealing or in charge of killing. So you cannot say man malaka shay'an malaka al-iqrar bih applies here. Did you get the difference? Now let's give another example for the other side. Vakil says that I sold your home. You gave me permission or authority to sell your home. I sold it. We accept. We cannot say إقرار العقلاء على أنفسهم because this was not his home. But we can say من ملك شيئا ملك الإقرار به. So sometimes both applies, like a person says, I gave my home to someone or to poor people. إقرار العقلاء على أنفسهم جائز من ملك شيئا ملك الإقرار. Both of them apply. Sometimes one of them applies. For example, if someone says, I killed this person or I stole his money, إقرار العقلاء على أنفسهم جائز. But we cannot say من ملك شيئا ملك الإقرار به applies here because he was not in charge of killing them or stealing them. Okay? And sometimes can be the other way around. Like what? Like the agent says, the wakil says, I sold your home that you gave me permission to sell. So he was in charge, we accept his declaration. Man malaka shay'an malaka al-iqrara bih. But we cannot say we accept because al-iqrar al-uqala ala anfusihim jaiz, because he's not losing anything. He's not causing any harm to himself or any loss to himself. So these two rules overlap. Sometimes both of them applies, sometimes one of them applies, and sometimes none of them applies. Now, what's the proof for each of them? Because there are two rules, so we have to discuss one by one. بالنسبة إلى قاعدة إقرار العقلاء على أنفسهم جائز. With respect to the rule of confession of rational people against themselves is valid. Some people said we refer to the Quran. Some people said we refer to Sunnah. Some said we refer to Aql. Some people said we refer to Ijma. So all four dalil have been mentioned. With respect to the Quran, they have mentioned few verses. For example, قالوا أقررنا or وآخرون اعترفوا بذنوبهم or ألست بربكم قالوا بلى كونوا قوامين بالقسط شهداء لله ولو على أنفسكم. So they say, look, إقرار, اعتراف, and giving testimony even against ourselves, these are mentioned in the Quran. Some people said Sunnah. There is a famous hadith quoted from Prophet Muhammad sallallahu alaihi wasallam. إقرار العقلاء على أنفسهم جائز. Actually, the same formula is mentioned as a hadith. Aql. Some people have said, actually, Aql tells us that إقرار العقلاء على أنفسهم جائز. Why? Because no aqil, no rational person would decide to harm himself So if he is saying something, there must be a truth in it. People may lie in order to gain, but people don't lie to lose. Yeah? So we should trust them if they are declaring and confessing against themselves. And also they said there is ijma, consensus, because there seems to be no alim who disagrees. Do you know any alim who says we don't accept confession of people against themselves? It seems no. But then Sheikh Irwani comes back and decides which one of these arguments actually are reliable. With respect to the Quranic verses, he says actually they are not related to our discussion. Yes, the last one, كونوا قوامين بالقسط شهداء لله ولو على أنفسكم. This is relevant because it says that we have to bear witness and offer our testimony بالحق, truthfully, even if it is against us. So this means that if it is haq, it's going to be accepted. But how can we say this is haq or not? So even this one seems not sufficient proof for the rule. So he says the ayah is telling us أن الحق إذا شهد به يلزم قبوله. When there is a testimony for haq, it must be accepted. But we don't know if there is haq or not here. The hadith also, it is very famous, yes. But where did this hadith get its fame? Sahibul Wasail, Hurra Amili Rahmatullah alayh, quotes this hadith, but from books on fiqh, not books of hadith. And he doesn't mention any major collection of hadith, any usul, those 400 usul, any collection of hadith which is reliable. He mentions books on fiqh istidlali. Okay? In Awal al-La'ali, as we had before, in few cases, in Awal al-La'ali, Ibn Abi Jumhur al-Ahsai mentions a hadith from Prophet. But this book is not reliable, it's mursal, and doesn't mention that, all the chain. And if you say that it is famous, and this fame, fuqaha have accepted and acted upon this, issued fatwa based on this, and this would be a good basis. He says, maybe they gave fatwa here in compliance with this hadith, not because of this hadith, but because of uqala, because of sirah uqala. So they have fatwa which is compatible with this. But is it because of this that they gave that fatwa, so that we say it strengthens the hadith, or they had another reason? They had sirah uqala. And then about aql, he says we cannot say it is aql. You remember the difference between aql and uqala? We had this before in usul al-fiqh. Aql means decisive, rational proof, which is very difficult here, because I don't think anyone can say aql says if you don't do this, it would lead to contradiction. If you don't accept his confession, it's causing problem. No. We can say, maybe he made mistake. He should bring it. But uqala means the way that rational people do, the people who have their common sense, they would normally listen to people who confess against themselves. So there is sirah uqala, which is different from dalilul aql. Dalilul aql means there must be a burhan, there must be a proof But Siri Uqala act like this. Okay? Like Khabar Wahid, Uqala accept Khabar Wahid, but we cannot say there is a rational proof, philosophical proof that you have to accept Khabar Wahid. Ijma, consensus, is not also valid, because whenever ijma can be madraki, it's not accepted. We have to refer to that madrak. Whenever there is a hadith or ayah and ijma can be because of their understanding of that hadith and ayah, we look directly into that hadith and ayah. We don't accept ijma. So ijma is not so applicable here. So what's the best reason then for this qaida? The best is siri uqala. In all societies, in all cultures, uqala listen. Courts make judgments based on confession. Which type of confession? Confession against themselves. I cannot confess that you owe someone. I can confess that I owe. What about man malaka shay'an malaka al-Iqrar bih? What's the proof for that? Sheikh Ziyauddin al-Iraqi, he says there is a mulazama. He says, if you have sulta, authority to do something, and then you inform about it, there is a mulazama. Whoever has authority to sell, he has authority to declare. Your information will be accepted, your declaration will be accepted. But Sheikh Irwani says, we cannot prove that there is mulazama. Maybe we say, he has authority to sell, but if he says, I sold, we ask for an evidence, at least one witness, for example. So there is no intellectual, rational necessity that when someone is in charge, we have to accept his declaration. Some people say we have hadith. For example, we have hadith from Imam Baqir alayhi salam. Inna Rasulallah sallallahu alayhi wa sallam said, Laysa laka an tattahima man qad i'tamantah. You should not accuse someone that you have trusted. So if you gave someone wakala, you say, you are my wakil and go and sell my home, and he says, I sold it for you, you should not question, because then it means that you are accusing someone that you have trusted. So they want to use this hadith. لَيْسَ لَكَ أَن تَتَّهِمَ مَنْ قَدْ ائْتَمَنْتَهُ. Okay? But this seems to be something that we cannot say it all the time. For example, for wakil we can say. But what about the one who says, I divorced my wife? Who has trusted him? I choose someone as wakil and trust him. But someone who is married and says, I divorced my wife, he has not been given any trust. Siraya uqala. Again, some people have said Siraya uqala. Uqala say that when someone is in charge and he says, I have done it, we accept it. He says, yes, but not 100%. And as you remember, we said whenever there is dalil al-lobbi, you have to go for qadr mutayaqqan. So as much as you are sure that uqala accept declaration of someone who is in charge, you can accept. Uqala accept for wakil. Uqala accept for someone who says, I have, for example, sold my home. This much they accept. Yes. Pardon? Lobby is opposite to lafzi. Like lobby means anything which is not linguistic, anything which is not a text. Like ijma, siray uqala, dalil aqli. These are non-linguistic. Some people, you're welcome. Some people have said ijma'. For example, Sheikh al-Ansari says, al-insaf anna al-qadhiyyat al-madhkura fil jumla ijma'iyyatun. But we say, yes, even if it is ijma'i, it is muhtamalul madrakiyya. Because it's maybe based on madrak. Because maybe because of Siriya uqala, they said this. So, we accept this, but you have to keep it to the places or cases that you are sure that uqala would listen to the confession. Now, there are exceptions. Inshallah, we have to discuss about exceptions, as I said, and maybe I can say this quickly because I already mentioned. If someone is confessing and actually something which is going to harm him, but he would benefit from it also, we said this is not accepted. Because iqrarul uqala ala anfusih. For example, he says, I have committed theft, but he wants to avoid a greater harm. He wants to be, for example, punished so that he doesn't go to war. There is military service and he has to go to war. Or if someone admits about fornication. Fornication is one of the things that one admission is not enough. Sometimes 4 admission is needed in the court or in front of the judge. So if it just says once, actually our hadith, tell us that Ahlul Bayt alayhimus salam, and this is the sunnah of the Prophet, they were not very keen to ask people to admit their sins. Because in Islam, you should keep your sins between you and Allah subhanahu wa ta'ala. Sometimes people wanted to get rid of the burden of the sins. They used to go and admit and say, tahirni, clean me. They wanted for punishment. But they used to avoid listening to this. So even if someone says once, they try to not accept. So in Islam, we don't accept in some cases, in zina, fornication, 1 admission. So sometimes admission is not accepted, sometimes once is not enough and has to be repeated few times. Inshallah, we continue next session on Wednesday. Wa akhiru da'wana alhamdulillah rabbil alamin.